Hey everybody, question for you. Is this a break-in tool? Well, maybe. Looks like a hammer though. How about this? Well, maybe. Looks like a window punch. How about this little crowbar? Maybe. It's hard to say. How about these lockpicks? You know, I think we might be onto something. Let's find out together. Guys, welcome back to another episode of Field Training with Hansy. I'm your host, Hans Gruber. Today we're going to take a little look at a section in the criminal code that talks about possession of break-in tools. An interesting question was asked in the group recently, and the author basically says, hey, if I'm patrolling my property and I come across a person where they shouldn't be, like in a back hallway, and they're holding a crowbar, can I arrest that person for possession of break-in tools? You know, that's a great question. Let's take a look at a few aspects together. First of all, let's look at our powers of arrest under the criminal code. So here we have 494 subsection 2. We've talked about this one a few times. So the owner or a person in lawful possession of property, or a person authorized by the owner, or by a person in lawful possession of property, may arrest a person without a warrant if they find them committing a criminal offense on or in relation to the property, and A, they make the arrest at that time, or B, they make the arrest within a reasonable time after the offense has been committed, and they believe on reasonable grounds that it's not feasible in the circumstances for a peace officer to make the arrest. So let's break down a couple of points here. Okay, first of all, may make the arrest. As I've discussed before, we may make arrests, which means we're not compelled by the law to make arrests. When we find these things happening on our property, whether there be cause disturbance or assaults or criminal trespass at night, things of those nature, we can use our skills. We can use our de-escalation, our TACCOM to see if we can try to remove the person and then refer the matter to the police. That's kind of the way I like to go. I think it's a little more professional at the end of the day. You know, you don't risk getting hurt. You don't risk injuring the other person. It's a lot less paperwork. And at the end of the day, it's the professional thing to do. Remember, our job comes down to two concepts: helping people and solving problems. Okay? Something else to consider here that's important to talk about is fines committing. So fines committing is defined as being in the same place at the same time as the offense is being committed and witnessing the offense with your own eyes. Okay? So that means being there when it's happening and seeing it. That means that we're not doing things like taking statements from people and relying on secondhand witnesses, third-hand witnesses, or watching it through the camera. We're there in the moment to deal with it. Okay? So let's talk about, before we talk about Section 351, possession of burglary tools, let's talk about break and entry in the criminal code. Okay? Section 348, everyone who breaks and enters a place with intent to commit an indictable offense therein, breaks and enters a place and commits an indictable offense therein, or breaks out of a place after committing an indictable offense therein, or entering the place with intent to commit an indictable offense therein, is guilty of, if the offense is committed in relation to a dwelling house, of an indictable offense and liable to imprisonment for life. Okay, B&E is pretty serious, guys. Okay, or if the offense is committed in relation to a place other than a dwelling house of an indictable offense, is liable to an imprisonment for a term not exceeding 10 years. Okay, and or on summary conviction. So essentially, if this is in relation to a dwelling, this is a very serious thing, whereas they cut the context up. If this is a commercial property, an industrial property, it's not such a big deal. Is it a big deal? Sure, it's a criminal offense, okay? But what is B&E? Okay, B&E is not really defined in Section 2 of the Criminal Code. It's really defined throughout many case laws that have been tried throughout the history of our country, okay? One of the definitions that I used to hear people say was, oh, they have to break something to enter. Well, that's not really the case. There's also called something breaking the plane. And that's just entering. You don't actually have to break something. Because remember, guys, a lockpick set could be used to break in, and you're not really going to break the lock with one of these. Whereas this hammer would break a window, would probably damage property. Okay? So some things to think about here. We don't actually have to break property to break in. It's called breaking the plane. Okay? So we've taken a look at break and enter. Let's take a look at section 351. What we're going to do first is we're going to look at the old section, because it's kind of important to look at where we've come from in history. Okay, this is section 351. This was repealed back in 2008. Okay, and I'll talk about why it was in a moment. So this is section 351. Everyone who without lawful excuse, the proof of which lies on him, has in his possession any instrument suitable for the purpose of breaking into any place, motor vehicle, vault, or safe, under the circumstances that give rise to a reasonable inference, that the instrument has been used or was intended to be used for any such purpose, is guilty of an indictable offense and liable to imprisonment for a term not exceeding 10 years. It's a lot of time. Let's talk about why this was repealed. A couple of things that come up here. You might see this phrase on here, the proof of which lies on him. And you might say to yourself, what is that? Well, it's what's called a reverse onus clause, okay? A reverse onus clause is a legal provision that requires an accused person to prove or disprove something, such as an element of offense or a defense, okay? Now, the interesting thing is we think about things like the Charter of Rights and Freedoms, right? We think about things like Section 11 of the Charter, and it guarantees things like, the reasonable belief that somebody's innocent until proven guilty in a court of law, okay? A couple of very serious cases that went to the Superior Court of Canada, Regina versus Oakes, Regina versus Laba, okay? Both cases ruled that reverse onus laws are unconstitutional. Particularly Regina versus Oakes, a 1980s case. The justice was quoted as saying, reverse onus laws violate the core values of our justice system. Imagine that. We're in a free country with democratic values, and we have laws on the books that consider people guilty before they're found innocent. That's kind of a scary thought, okay? So over the years, they've been cleaning up the criminal code. They did a big sweep of this back in 2008, and another one recently, just cleaning up a lot of these reverse onus laws, okay? Now, the other thing to think about here, we looked at the particular section. It's an indictable offense, okay? Is having this an indictable offense? Well, it could be. That's just a hammer, guys. Things to think about, right? What we have now, it's been transformed and rewritten into a dual procedure offense, okay? Or a hybrid offense, as you may know it, okay? Dual procedure offenses are offenses that can go either as a summary conviction or be processed as indictable, okay? And the Crown will elect which way to go. On arrest, dual procedure offenses are always treated as indictable, okay? So what we have here is Section 351. This is what is currently on the books as of 2021. Section 351, everyone who without lawful excuse has in their possession any instrument suitable for the purpose of breaking into any place, motor vehicle, vault, or safe, knowing that the instrument has been used or is intended to be used for that purpose. So is this a B&E tool? Well, it's a hammer. No. But if I were to use this to break in, well, then it becomes a B&E tool, because that's what it was used for. That's really the important piece here. Does that make this a B&E tool? Well, no. But if I use this to break a car window for the purpose of stealing or breaking in something out of the vehicle, then yes. How about this pry bar? Okay, same thing. This is a lawful and reasonable tool for anybody to have for all kinds of things. But if I use this to break into something, it becomes a burglary tool. How about the lockpicks? Because you might think, well, these have a very specific purpose, and that's breaking into things. Well, if I break into my filing cabinet, is that criminal offense? Not really. And I use these to break into my filing cabinet once in a while, because I might have misplaced the key. It works real good. But lockpicks are kind of fun. Okay, there are a lot of people that like to challenge themselves with lockpicks, and it makes things really interesting. Okay, so is it illegal to have a set of lockpicks? Well, no. Okay, something to think about though. If I was to take that and throw that in my backpack and go for a stroll, and the police are called to a B&E nearby, and the subject just happens to look like me, and I get stopped because I look like the subject, and through a search, B&E tools are found, well, I could be in a little bit of trouble here. So some things to think about, right? Okay, so think about that. We also want to think about trespassing, because as the question came up in the group, the person was trespassing. So here we have the Ontario Trespass to Property Act. I like to use Ontario as the example because typically all three of these categories, engaging in a prohibited activity, entry where entry is prohibited, and failing to leave when directed to do so, are really what constitutes trespassing. Okay, so every province has their own trespass laws. I like to use Ontario as the example because most of the other provinces use the same things. Whether you in your province are allowed to actually arrest and deal with a trespassing situation, that's another situation. As in BC, security professionals there, they don't deal with the Provincial Trespassing Act because I think of the clause in the Safe Streets Act, something to the effect. But let's look at Ontario here. Section 2. Every person who is not acting under a right or authority conferred by law and who, without the express permission of the occupier, the proof of which rests on the defendant. Again, another reverse onus clause, guys. Enters on the premises when entry is prohibited under this act, or engages in an activity on premises when the activity is prohibited under this act, or does not leave the premises immediately after he or she is directed to do so by the occupier of the premises, is guilty of an offense, and on conviction is liable to a fine of not more than $10,000. Okay, well, that's pretty serious. Is it trespassing to have these things on you? Well, not exactly. But if I'm in the back hallway somewhere where I'm not supposed to be, and you figure out that I'm not supposed to be there, that is entry where entry is prohibited. And let's look at it from that point of view. Okay, so to sort of conclude things, to wrap things up here, it's not illegal to own things like lockpicks. It's not illegal to own things like, I don't know, hammers, crowbars, pry bars, etc. Okay, what is illegal is to use those items in the commission of a break and entry. Okay, now, if you're on your property and you find somebody with this, it would be really difficult for you to be able to articulate that that is the situation. And really what you're going to be dealing with is either the trespass or the break and entry element of the situation anyways. Okay, so I hope this has been helpful. This is Field Training with Hansy, guys. Drop a like and subscribe for more videos. Stay tuned, stay frosty.
Flashlight Man!